Hello, my name is attorney Jason Lyle, and I am the Oklahoma Will and Trust.com attorney for Northeastern Oklahoma in your area. I'd like to talk to you a little bit today about something that causes some confusion amongst my clients when it comes to estate planning. I often get approached or asked by new clients to draft a trust or a will, and they want to know the difference. Most people don't understand the difference. So let me tell you a little bit about the difference. The nice thing about a trust is that if the condition that springs it into existence, meaning you're your own trustee unless and until you become incapacitated or you die. When one of those things happens, your successor trustee takes over and has the power over the property that's put in the trust. Okay, the trust contains instructions for that to happen. A will is basically the same thing. It's a document that says when you die, then you nominate somebody to do the same thing. But the main difference, and this is important, is in order to get power that's given to somebody by a will, that person or somebody else has to file a probate action in the district court. Because when you file a probate action, you're essentially asking the judge, please recognize that this person died in this county and they died with a will, if that's the case, or without, but that if there's a will, they died with a will. Who's asking to be the personal representative? Does the will name somebody? Does anybody object? It's only then, after you get past that first hearing that determines those things, that the judge signs some documents called letters testamentary, if there's a will is what they're called, and an order declaring who the heirs are and who the personal representative is. So until you have those documents and they're filed with the court clerk, you, as the personal representative or whomever you appointed, will not have power to help you manage your estate. So we often tell people we draft trusts to avoid probate, because if somebody's not going to sue you into probate, a creditor or a family member, then the trustee will have power immediately over the estate by virtue of the trust, and they don't have to go to probate court. So that is the main reason that we draft trusts more often than wills, and the main difference. A lot of times you'll hear us refer to a pour-over will, and you've heard this in previous videos of mine, which is just a document that's a just in case. In case you get sued into probate court, the court will know that you poured over everything into the will that you own. So it's a way to say all my stuff is in the trust, whether it's listed or not. At any rate, that's the difference. If you have any questions about this or any other estate planning issues, please feel free to look me up at oklahomawillandtrust.com. Our number there is 918-876-4500. And again, my name is attorney Jason Lyle. Thank you.